All right, so we're going to go ahead and get started. Good evening, everybody. Thank you for being here. My name is Ryan Owens. I'm the director of the Institute for Governance and Civics here at Florida State. We're very, very happy that you are here. I'm going to say a few very brief words, and then I'm going to hand it over to Professor Doug Norton. Just briefly about the IGC. Who are we and what are we trying to do? Some of you may not have heard of us. I know we've got some freshmen here who haven't heard of us before. Welcome. Thank you for being here. So at the IGC, we aim to be the nation's premier policy institute in creating effective citizens and responsible leaders. And we're doing that by advancing constitutional, economic, conscience, and education liberty. And those really serve as the four pillars of liberty that lift up the IGC. We're doing that through bold research, transformative teaching, and fearless debate, which is becoming harder and harder every single day around the country. But in that spirit of debate and discussion, I want to invite all of you, and those of you who may be watching this later, to some of our upcoming events. And you can find out more about these events on our website, which is igc.fsu.edu. And this is a great list. I mean, it's a great list. Many people are saying it's the greatest list ever. We have this panel tonight. Obviously, we've got some fantastic speakers talking about occupational licensing reform. We're very excited about that. Coming up in the future, on September 19th, Rich Lowry from the National Review will be here to speak about the Constitution and the meaning of America. On October 1st, Professor Andrew O'Shaughnessy will be here to talk about Thomas Jefferson and his views on the university and how we've lived up to that, perhaps how we haven't, and whether that's a good or bad thing. October 2nd, we have an event at the law school called Free Speech on the docket. This will be a panel of Supreme Court litigators and scholars who will talk about the upcoming free speech cases on the Supreme Court's docket. October 7th, we have David Newmark, who will be here talking about the propriety of using minimum wages to fight inequality and poverty. October 15th, Vlad Kogan will be here to talk about how politics hijacks education policy and hurts kids. October 24th, the Founders and Religion is a panel we're hosting here, as well as a panel on the creation of the Constitution. Whew, if that wasn't enough. November 4th, we have Daniel DiMartino, who will be here to talk about how socialism destroyed Venezuela. November 10th, we'll talk about the regulation of AI. We'll have a fantastic panel here about that. November 18th, Glenn Lowry will be here to talk about the case for Black American patriotism. And then on November 19th, our own James Schulz will be here to talk about his new book, Fighting for the Freedom to Learn. So we welcome you to all of these events. In addition to that, in honor of America's 250th, we'll be celebrating a number of movies that are celebration of America throughout the upcoming academic year. So these will be a series of movies held at the Student Theater as well as the Challenger Learning Center IMAX Theater. Stay tuned for those movies when they are and where specifically they will be held. All right, so thank you again for being here. On to our moderator for this evening and our discussant, Professor Doug Norton. So Professor Norton is a professor in the economics department, and he is the head of the economic liberty branch here at the IGC. Since joining the faculty in August of 2020, he's taught a variety of economics courses, including intermediate microeconomics, economics of state and local development, health economics, econometrics, and other courses that I would not have passed had I taken them. In research, Doug uses economic experiments and applied microeconomics to understand important normative questions of the day. So we are very happy that Professor Norton is with us at the IGC. I am personally very happy to have everyone here on this panel joining us and very appreciative of you in the audience. So if you would, please welcome Professor Norton to kick us off.
So first of all, thank you to Ryan for that introduction. We're kind of kicking things off. This is the very first talk on the economic liberty in the economic liberty branch. So I'm going to start by just reading some brief notes of a mission that I wrote. Through education and research, our mission is to form leaders and citizens who understand that liberty in commerce and industry is the surest path to human flourishing. By fostering knowledge of competition, opportunity, innovation, and the strength of community life, we strive to preserve for ourselves and for future generations the promises of life, liberty, and the pursuit of happiness. I'm delighted to introduce these speakers tonight. The first speaker will be FSU's own Mark Isaac. He's the John and Hallie Quinn Eminent Scholar Chair, and he's a pioneer in the area of experimental economics. His research on cooperation in groups, competition in markets, risky decisions, and other areas has appeared in many of the top journals in economics. In addition to publishing in top journals, Mark has been a terrific leader for the economics department, serving as department chair for 6 years, and has been a terrific mentor to numerous FSU undergraduates and grad students, including me. Our second speaker will be Morris Kleiner. He's professor and AFL-CIO chair in labor policy at the Humphrey School of Public Affairs at the University of Minnesota. He's published extensively in the top academic journals in economics on labor policy and has affiliations with numerous organizations like Brookings, the Hoover Institution, Federal Reserve Bank of Minneapolis, and others. He's one of the foremost experts in the world on occupational licensing, the topic that we're discussing tonight. Our third speaker is Jamie Kavanaugh. She is State Policy Counsel at Pacific Legal Foundation, where she works with legislators around the country to end burdensome laws and create opportunities for individuals to thrive. She has worked in many areas such as certificate of need laws, but tonight she'll be talking with us about occupational licensing laws. So I want to thank everybody for coming out to the event. I appreciate your presence, and each speaker is going to have about 15 minutes. Then we'll have time for Q&A at the end. So get your questions ready. Thank you.
Doug, do you want us up there, or do you want us to just talk?
Go ahead and
go up?
Yeah.
Okay, all right. Bring my watch so that I don't overstay my welcome. Thank you for the invitation. It's a pleasure to be on the panel with two such distinguished researchers in the area of occupational licensing. Thank you, Doug, for the very kind introduction. Thank you, Ryan, for the Institute. And what I wanted to do was to say that I am a consumer of the types of research that is going to be discussed here tonight, not a producer, which is why I want to come on first and get out and let them talk. The way I'm a consumer is I taught frequently at the undergraduate level and graduate level on economics of regulation. And I've done a lot of research on regulation, never on occupational licensing. So it's going to be a real treat for me tonight to hear these distinguished guests talk more about that. I'm really looking forward to hearing what they have to say. The tack I take with undergraduates is a kind of a dichotomy, although we'll see that it has a few more edges around it, between the so-called public interest view of regulation and alternate views of regulation. Guided, by the way, when I did this for years, by a textbook written by Stephen Breyer. Now that name may sound familiar to you because he served on the United States Supreme Court. Few people realize that he had a career, a very distinguished career as an academic in law and economics. And you may not realize that he would write a book about regulation that a diehard, down-the-middle microeconomist would use to organize a discussion among economic undergraduates. And this initial dichotomy is along the ideas that we might call old Samuelson textbook economics. Probably nobody here is old enough, unlike me, to have gone through the university and have the only textbook that was probably available for economics be Economics by Paul Samuelson. And that kind of background was always, well, here's why we have government. And it's, we have a failure to have competitive markets, so we have antitrust, and we have a different type of failure of competitive markets called natural monopoly, and that's why we have rate of return regulation. Okay, fine. The problem with that is people have looked at the way that regulation actually works, and it doesn't really match the model of people coming in and implementing policies that match that. And so on a continuum, the the most opposite view of the world that you might take from that. It came later from the Virginia, what was then called VPI, now called Virginia Tech, George Mason Group, and associated people also at the University of Chicago with George Stigler, and also some people at UCLA, kind of that universe called the public choice model of regulation, which views actors in the regulatory process as maximizing something in their own self-interest, with the extreme version of that being the so-called capture theory, which is that regulation is ultimately captured by the entities that it's trying to regulate and taken over for its own benefit. Now, it's certainly true that we can come up with a lot of good examples of capture theory of regulation. Round 2 of the Interstate Commerce Commission, after it was originally declared unconstitutional by the Supreme Court and then reconstituted, was indeed an example of that. More recently, and in some of our lifetimes, the Civil Aeronautics Board regulation of fares and entry into the domestic airline industry was almost indistinguishable from what you would get if you had a perfectly functioning cartel for the airlines. And there are other examples. But let's not say that these are the only two possibilities. There have been some other options other than the pure public interest theory and the pure public choice theory. Breyer does talk a lot about the public choice and capture types of theories, but he presents another problem with regulation, another alternative to public interest theories, which doesn't necessarily rely on the idea that people's motives are self-interested in a way that isn't aligned with the public good. He calls it the mismatch theory, that even well-intentioned people can adopt policies that they think they've read in some prior textbook or something like that, and they've simply adopted policies in an area that perhaps needs regulation, but they've chosen a tool that doesn't at all match the situation. The classic case of Stephen Breyer was natural gas price regulation at the wellhead. Probably few people here could ever imagine that Stephen Breyer was one of the most ardent flag carriers for deregulation of the price of natural gas at the wellhead. Probably doesn't match your picture of who Stephen Breyer was. And it's precisely because he viewed it as an incredibly bad match for the problems that were in the natural gas industry. It was treating natural gas production at the wellhead in the same way as natural gas distribution in the city, which it most certainly was not. And people were attempting to apply the same tools, which certainly was not a good thing. Another alternative to this is, which I think has gotten very little attention compared to what it deserved, was put forth by Owen and Brodigan in a book. And their argument is kind of a private interest view of regulation, but it's private. They view it as private interest largely of voters who see regulation as a type of social insurance against risk in their lives. Okay, that one thing that might happen, or bad things, whether this is safety or I lose my job because someone comes in and develops a new technology that makes my job obsolete, and so on and so forth, that there's a very strong tendency for voters to put in place roadblocks against change for very personal reasons of risk aversion over their own financial future. I think that regulation as an impediment to risky outcomes for the voters has gotten much less attention than what it deserves. So those are the extreme capture theory, the public interest theory, regulation theory, the mismatch theory are all things that I go over with my students as models of regulation and the problems that they entail. Another thing I want to say before I turn it over to my distinguished colleagues is that these things are not necessarily always an either-or situation. I was always struck by a paper by something like 11 or 12 years ago in the Journal of Law Economics by Law and Marx, which is an historical examination of licensing, exactly the type of stuff that we're talking about here today, and its effect on African Americans during the period of Jim Crow. And you can easily see how either the public interest or the capture theory might fit into that, particularly a capture theory that says that these licensing requirements were put in for the specific reason of disadvantaging African Americans. That's certainly the case. If you want to, you can go back and read events in real time at the institution of the minimum wage to realize that there was a lot of racist sentiment behind the initial institution of the minimum wage that was aimed at both immigrants and African Americans. I mean, this is just well known. So maybe the same thing could be true for occupational licensing. But there's another view, a more public interest view, is a license, and Morris will be talking about the gradations of regulation, which I think will be very interesting in terms of licensings versus certification and so forth. But that it provides a signal to the market that perhaps was valuable to African Americans in a world in which there was prejudice. And this particular paper, and I'm grossly summarizing the results, and I apologize to the authors, I'm doing this in about 2 minutes, basically kind of shows the heterogeneity across a number of different professions. With on one end, barbering being a case in which the licensing of barbering looked very much like a capture theory designed to disadvantage African Americans and provide entry barriers to keep them out of the market. Whereas skilled nursing seems like it had the effect that was more consistent with the public interest theory that provided a way for African Americans to get a signaling value that helped them out. So this is we're in this world of occupational licensing, and there's also here's some heterogeneity. The final thing I'll say is that one thing that I always caution my students about is we're talking about these theories in terms of the policies that are adopted. We're not psychologists. And so when we use these words like public interest versus capture theory and private interest, we're not making statements about the morality of the people involved, or their psychology, or whether they're good or bad people. And the most amazing example I ever had of that was, this is while I was at the University of Arizona and teaching one of these undergraduate courses, and I'd gone through all the stuff, we'd gone through the capture theory regulations. I'd used the domestic airline industry as an example, and I got this call from the dean's office, and they said, Mr. X, who is the retired president of Airline X, I won't mention what airline it was, but he's settled in Tucson, and he would really like to come interact with students, and we found out that you teach the economics of regulation, and I thought, yeah, this would be kind of interesting, so we invited him in. It was fascinating. He talked the entire time. He had grown up during the Great Depression, so his entire worldview, which may or may not have been economically accurate, was that the problem of the Depression was that prices were falling, so that the way you stopped the Depression was try to keep prices up. Now, we all know that Milton Friedman would say that this is getting cart and the horse backwards, but nevertheless, this is someone who grew up in the midst of that and wasn't necessarily tuned into that view of the world. And he passionately told his students that the worst thing that ever happened in the United States was deregulation of the airlines, because this was all put in place under Franklin Roosevelt, who pulled the country out of the Depression, and this was part of pulling the country out of the Depression, and this was part of the reason we got out of the Depression, and that if he were president, he'd immediately put a stop to these stupid economists who had done this and return to a world, in fact, that the existing world before deregulation of the airlines wasn't tight enough. There were still too many airlines. There were like can't remember, 8 or 11 legacy airlines. And he said, you know, what we need is like 2 or 3 airlines, and they meet in the office of the president 4 times a year, and they set a fair price. And you know, on and on. And I'm just going, hey guys, you know, and the next class I said, so what do you think? Do you think the capture theory regulation is a real thing? And my students are all going, yeah. I said, do you think he's being insincere? Or do you think he really believes this? Do you think this is someone who grew up in the Depression, who saw a world in which people were unemployed and prices were falling, and that this policy was one of President Roosevelt, and President Roosevelt is given credit, perhaps incorrectly, for getting us out of the Great Depression, but he believed that, and that to him, this really is public interest theory. And actually, the vast majority of my students believe that he was speaking sincerely, that he really believed that the system I've just described was what was in the public interest. So he wouldn't, you know, if the idea of coming and telling him, well, there's a public interest theory and there's a private interest theory, just wouldn't have computed. So I'll just close right here in saying, I've told you I've done work in regulation, primarily on things like electric utilities, natural gas, gasoline, and so forth. I've never been a producer of research on occupational licensing, but when it comes to this match and mismatch, where we got was the one I haven't mentioned to you, is this amorphous idea called information. Always comes up. But somehow there's this idea that the market doesn't produce information well. It goes back to particularly to people like Joe Stiglitz and Ken Arrow. And so people don't have the right amount of information to know to not put their hand under their lawnmower while the lawnmower is running. So we have the government come in and mandate a kill switch on your lawnmowers, all right, which we didn't have when I was 12 years old and mowing the lawn, all right? And this isn't an externality issue. It's not a monopoly issue. It's an issue of an assertion that somehow people in the market cannot process information correctly. Now, behaviorally, there may be some really strong reasons for that. There were not 0 people who got big injuries with lawnmowers that didn't have kill switches on them. There were a lot of people who had serious injuries from lawnmowers that didn't have kill switches. But the problem is that these theories are always just, they were never nailed down in the same way that some of these theories about externalities and natural monopolies and regular monopolies were. It was always kind of loosey stuff. And so applying public interest theories versus self-interest theories was always kind of hard. So I'm going to be sitting back there and thinking about this. You know, the next time I teach this regulation theory, I look forward to what my colleagues have to say about this specific thing that I haven't done a lot of work in, but I've always felt was kind of a hole in my class, which are these issues about licensing, regulation, certification, information, providing information, and so on and so forth. So I'll turn it over to my other colleagues now. Thank you.
Well, thank you for the invitation to come to Florida State. I've had a great day and had a great opportunity to meet with some of the economists. When I was out in the hall, I noted that many of you are not economists and wanted to let you know that economists are people who are pretty good at math but don't quite have the personality to become accountants. So just to let you know the kind of people you're dealing with. And when they asked me why I wanted to become an economist, at least initially, I heard it was it was inside work and no heavy lifting. So I was all in on that part of the profession. But the other issues with respect to economics and regulation was that that I got interested in this when I was working in Washington. At the Brookings Institution, I was assigned to the Department of Labor, and my boss, since I was the rookie in the group, said, no one else wants to work on occupational licensing, and you're low person in terms of seniority. Why don't you go do it? So I went out and started working on the issue and ended up with people at the Federal Trade Commission. And I found it was a fascinating and interesting issue, and even found out later that in Capitalism and Freedom, Milton Friedman had a whole chapter devoted to occupational licensing. So I'm going to talk about some of the background on the empirical work, what's been done over the last number of years, and then I'll turn it over to Jamie to talk about some of the policy issues. This issue is really the elephant in the room when it comes to labor market institutions. If you were sitting in the audience in the 1950s when Milton Friedman was writing about this issue for Capitalism and Freedom, only 1 in 20 workers were required from government to have permission in order to work. Now that is 1 in 4. When you add up all the people who belong to trade unions, plus all the people covered by the federal minimum wage, it's about half the number of people who have to get permission from government in order to work. So this is in the labor market is the big issue, is the big labor market institution. And one of the key issues is how did it get here, and why is it so big? And why are nations, I'll get to this a little bit later, why are nations all around the world looking at this from the United Nations to the Organization for Economic Cooperation and Development are all spending time and resources examining the role of occupational licensing. Now, many people think it's occupational licensing or nothing at all. But in fact, there are many different ways of regulating work and ensuring quality and making sure that incompetent and unscrupulous individuals do not engage in work. First of all, there's the market. And the market serves as a great regulator of quality. If the word gets out that you're not giving good haircuts, you'll go to somebody else. Also, if you're in a more high-risk area, for example, if a tree fell on your neighbor's garage and you want the tree removed, you can call a licensed tree remover. Now, that individual will likely be bonded. So if that person doesn't remove the tree correctly, you can sue that individual and get resources as a result of poor performance. Then there's registration. So oftentimes there's a list that the government lists of individuals who have provided high quality work. In the private sector, organizations like Angie provide those types of lists. Then there's certification. And certification is a right to title. So someone who's a chartered financial analyst does individuals' estate planning. Only those individuals under law can use that title. But you, if you don't use the title, can provide services to individuals. But at the top of this pyramid is occupational licensing. And that the government gives certain occupations a monopoly to provide certain services. So only a doctor can provide certain types of services to their patients. If you or I tried to provide those services, even though sometimes people call me doctor, I would be fined or hauled away to the local penal institution. So those are along a continuum of different ways to regulate the labor market and make sure that individuals have competent and unscrupulous individuals are not providing services. Now, what effect has occupational licensing had? Well, first you can look at what effect it might have on, as a labor economist, I would look at wages. And in the context of wages, licensing raises wages. It's not surprising. You need additional human capital to get into a particular occupation. That limits supply and drives up wages for individuals in the occupation. On the other hand, additional training might be a signaling or provide credentials that this individual has done a certain amount of work, and that the state gives that person the good housekeeping seal to provide those services. So licensing individuals are willing to pay more for those credentials. On the other hand, if you have fewer people, that may be driving up the wage. Also, one issue is with respect to inequality. Licensing restricts entry, and those people who are fortunate enough to be regulated can ask more money, and they tend to be at the upper part of the income distribution. So consequently, one effect of occupational licensing is to raise inequality because individuals who are unregulated get all the people who perhaps couldn't get into those licensed occupations, driving down wages for workers who aren't able to keep a lot of people out. So licensing, given that it's a monopoly and sort of economics 101, is licensing reduces competition. It reduces employment, and if it reduces employment, it also reduces competition for individuals in licensed occupations. Well, how did licensing go from 1 out of 20 to 1 out of 4? Part of it is a change in the economy. If you were a worker walking around the shop floor at a Ford Motor Company plant in 1946, and you found a genie coming out of the bottle, and they said, well, in 50 or 60 years, there's going to be, rather than about 40% of all workers working in manufacturing, it's going to go on down to 6. And you would tell the genie, that's awful. There's not going to be any cars. There won't be any clothes. People will be unemployed sitting on the front porch. And in fact, none of that happened. Instead, people went from working in manufacturing to working in services. In manufacturing, unions dominated. So in the 1950s, 1 out of 3 workers belonged to a trade union. Now that in the private sector, it's down to 1 in 20. And about 10% of all workers now join unions. And where have those workers gone? They've gone to service sector. And in the service sector, licensing dominates. So the structure of the economy has resulted in a very dramatic increase in the number of licensed workers, because they serve in many ways the same way that unions did in the 1950s, limiting entry, making sure wages are higher, and ensuring the quality of the workforce. Unfortunately, this reduction in competition has also reduced access. So in certain rural areas or certain urban areas, it's very difficult to get doctors, lawyers, and nurses to work in those areas. And the result is individuals who live in those areas have reduced access, and oftentimes at a much higher price. Licensing has reduced geographic mobility. In the US, licensing is state by state. Well over 80% of all licensing is at the state level. And each state has its own set of requirements. So if you want to be a hairdresser and you want to move from Wisconsin to my state of Minnesota, you have to spend almost a half year or longer learning the Minnesota way to cut hair. And we all know that hair in Minnesota is a lot different than Wisconsin. So those are other issues that tend to come up, is that each state sets its own barriers, so it's very difficult to move across state line, which reduces the economic efficiency of labor markets. And there's lower employment in certain fields. As a result, as I mentioned, it's tough to get access. their battles between the licensed occupations. What can doctors do versus nurse practitioners versus nurses? What can occupations such as lawyers provide different types of services versus individuals who are legal aids? All those are issues that come up when you have the government or licensing boards, which are an offshoot of the government, determine what certain people can do. Then there's occupational sorting. Some individuals may be pushed into lower paying jobs, move into unlicensed jobs due to licensing barriers. And there's some evidence on that. And the issue also comes up with respect to quality. You would expect that the benefits of licensing is higher quality. And in the empirical work, that's really open to question. Some work that I've done with respect to Uber, for example, New York City licenses, you must be a licensed driver to work for Uber in New York City. In New Jersey, that's not the case. So we did an experiment to see if customers thought that licensed New York drivers do a better job in terms of customer satisfaction or customer safety. And you can measure customer safety, and Uber does that by looking at hard starts and hard stops, which are correlates of safety. And there was basically no difference between the licensed Uber drivers coming out of New York City and the unlicensed New Jersey Uber drivers. And there's also a lot of work that's been done with respect to the costs and benefits. Governments, in terms of what ought to be happening, and we'll get into this later, is governments should rigorously evaluate the necessity of licensing before implementing whether additional licenses should occur. So there's huge variation in licensing across states. So for example, in the great state of Florida, interior designers are licensed. And the story there is, of course, it's health and safety. You walk into your neighbor's house and the drapes are ugly, you could have a heart attack. So you want to make sure that high quality is maintained for interior designers, and as a result, licensing is the way to do that, at least in this state. So these are all issues that tend to come up with respect to occupational licensing. It's an issue that has gone on and is occurring and is being examined not only in the US, but around the world. Now, the US has a real advantage for occupational licensing. One of them is we have great data. So for those of you who are considering doing additional research, the US is the place to do it. And this came about as a result of people working in the Obama administration were very interested in occupational licensing. And one thing in terms of the politics is that licensing tends to be a nonpartisan issue. So that both in the last 4 administrations, going back to President Obama, President Trump, President Biden, and the second Trump administration, all have had individuals to examine and to promote reduced regulations and the relaxing of occupational licensing requirements. So these have all been important issues when it comes to dealing with licensing. And the data that's available was really started during the Obama administration, where Alan Krueger, who is the head of the Council of Economic Advisors, was very interested in the issue. Former Commissioner of the Bureau of Labor Statistics, Catherine Abraham, was involved and was also very concerned. And fortuitously, they were dropping questions on the current population survey. And Erica Grosjean, who at that time was a commissioner of the Bureau of Labor Statistics, had gone to school and had worked with both myself and Alan Krueger. So we were given insider information that dropping questions, and now here's the time to add questions on occupational licensing. And we did that, and as a result, starting in 2015, There's data on most of the government databases, including the current population survey, survey of income and program participation, a survey of college graduates, all ask questions on is it legally required to have a license to do your job? So in terms of being able to look at the costs and the benefits, it's easier to do that in the United States relative to virtually any other country in the world. And we have really been an outlier in terms of work that's been done. And this has led, Milton Friedman was very discouraged. He was interviewed in early 2000s that his work really had not found its way into public policy. When it comes to occupational licensing, that's not the case. A number of us who do research in the area have spawned out. We've testified in Congress in both the House and the Senate, but we've also had an effect on state government. In 2019, Doug Ducey, who was then the governor of Arizona, because Arizona was gaining so many workers, but there was what he deemed as a shortage of licensed workers, passed the first law which allowed individuals from other states to come to Arizona and start practicing immediately. Since that time, and this is only 2019, 27 additional states have passed laws granting workers who are moving to Arizona to get licenses immediately upon being declared a resident and paying the appropriate licensing fees. So that's been a real change. There's also been movement in terms of different pathways. The example of that is someone you may have heard of, Kim Kardashian. Rather than going to law school, she worked in a law office. And after many attempts at passing the California bar exam, she passed. And rather than going to a prestigious California law school, she became a lawyer and can do work in the state by working for a lawyer, learning the trade, and passing the exam. So there can be different pathways to becoming licensed, and that is a new direction for occupational licensing research and policy. So with that, I'd like to conclude by saying that occupational licensing is the real major factor in the labor market. It's the major institution in the labor market. It has been rapidly growing. There are new occupations like genetic counselors that are seeking to become licensed, and that's largely due to the movement to the service sector. And this is an area that has seen both growth, a lot of research, and it's an area that I hope legislators across the state of Florida will look into and assess who gains and who loses as a result of this important labor market institution. And with that, I will introduce Jamie.
Thank you all for joining us here tonight, and thank you to the IGC for inviting me here. So we have heard some really important information kind of setting the table and getting us up to date on what the research shows about occupational licensure. So for those of you in the audience who might be concluding this is a bad thing, or this is hurting workers, this is hurting users of services, you might be wondering, what can we do about the problem with licensure? So I'm an attorney, I'm not an economist, and I've spent my career working at public interest law firms. Most of what I've done is litigation against the government, and now I'm in a different role where I work with legislators all around the country in many states to try and repeal and reform laws that are hurting people, and especially in the economic liberty category. But I want to start by telling you about a case I worked on in Georgia, because what we've been talking about so far is, we're zoomed up at a higher view, and I want to focus on, well, who are the people who are hurt by these laws? So Georgia tried to institute a license for lactation consultants in 2018. It had been proposed in the legislature actually a few times before that, and it had failed. And it was the private one of the organizations that certifies lactation consultants was the group lobbying to create this license. And of course they said, we have to create this license, we have to protect mothers and babies, and you have to make sure that our training is the only training that anyone in the state can take. Never mind that there's only 3 other states right now who license lactation consultants, and never mind that those licenses are, I think one's voluntary, I think 2 actually of the 3 are voluntary, so you could continue working without licensure. In the healthcare context, some people believe you need to be a licensed profession to get insurance reimbursement. I don't think, strictly speaking, that's 100% true. For instance, we know there's lactation consultants in states that don't have licensure, that don't have a licensure scheme, who get reimbursed from insurance. But that's something else that goes into the argument to try and convince legislators when you're rent seeking for your own certification. You say, send all the students to us. But you know, the first thing Georgia should have done, and correctly did do, was look around at the rest of the country and say, why isn't anyone else licensing this? Georgia actually used to have a review commission that would review proposals for new occupational licenses. It has been defunded and they don't have that anymore. But that group correctly pointed out that this would be a very harmful license. It would increase costs, it would decrease access for the most vulnerable patients. And you know, looking at other states, they saw no evidence of harm that this license was trying to correct. And that's really what we want to see when we're talking about creating a new license or changing maybe existing licenses, whether we're making it harder or easier to enter a profession. We want to see what are the real world harms on the ground, and kind of how is this solution, this license, or maybe it's a certification, or maybe it's just bonding or insurance, how do these solutions relate to that problem that you're trying to solve? So my clients in Georgia are 2 women who are really pioneers in the breastfeeding space. They've both been served on the US Breastfeeding Council, but they really started the model for having lactation consultants available in maternity wards in hospitals, in labor and delivery units. So they've been doing this work for decades, but one of my clients didn't have the right type of certification or training. So even after more than 25 years of practicing in this field and teaching doctors how to talk to new moms about breastfeeding, she would have had to stop her job and go back to school for 2 years and pass a new exam to continue doing the job she'd been doing for decades. So we sued about this. And also she, along with her friend, started an organization that provides free lactation consultant services for anyone, but really they targeted it at their community, the African American community, and they said, you know, what someone needs when they're looking for breastfeeding advice is someone who looks and talks like them. That's when you're gonna be most comfortable talking to this person, having this experience with them, and this isn't a medical profession, this isn't a medical job. This is really cheerleading. This is giving new moms who are tired and, you know, new to this experience, giving them some support, telling them they're on the right track, giving them other options if breastfeeding isn't working out for them, showing them other ways that they can accomplish their goals. So we sued about this, and it took 2 years to go all the way to the Georgia Supreme Court because the state, you know, this happens in all of our lawsuits, but the state argues you don't even have a right to be in court. So economic injuries, if you are in a business and the government passes a law or a regulation that interferes with your ability to earn a living, that right is protected barely at all by the courts. You know, free speech, freedom to practice religion, some of these other rights are way up here, and then, you know, the right to earn a living is really relegated to no importance at all to the courts. So we fought for 2 years about whether we could even be in court and whether they even had an injury, an economic injury. And the Georgia Supreme Court said, yes, you can continue. And then we fought for another 2 years and ultimately won a huge victory where the Georgia Supreme Court said there is no reason to license lactation consultants. The state was unable to produce not even a single document showing harm to someone in Georgia or someone anywhere in the country from an unlicensed or untrained lactation consultant. And then the court kind of laid out a new test for, in the future, if someone is complaining of this type of economic injury, this is how courts in Georgia have to review those claims. So it's huge and it's really important, but it only protects workers in Georgia. It doesn't extend to federal courts. And very few other states have kind of adopted this model to protect economic liberty. But that's a project that Pacific Legal Foundation and Institute for Justice and others are working on to try and get state courts to be more cognizant of economic rights. But some examples of another case that we lost was a case licensing florists in Louisiana. Louisiana was the only state that had a florist license. I think they still have it, but it might be more like a registration now. And you actually had to come in and do a practical exam and make floral arrangements, and you were judged by other licensed florists, your direct competitors. The passage rate for that exam was lower than the passage rate for the bar exam in Louisiana. But Institute for Justice had sued about that license, and we would all think that would be an easy one to win. But they lost that case, and the judge made up his own reason for why the law was rational. It wasn't anything that the government argued during the case. It wasn't part of their evidence that they brought to the case, but the judge said this license might protect people from infected dirt. I've never heard of this. There was no evidence that infected dirt is a problem. As I said, every other state does not license florists, so they're doing okay without it. But just another example of pretty much the most irrational license we can think of, but that one failed in court. The court upheld that license. So aside from litigation, I told you I work with legislators now to try and change laws. And Professor Kleiner mentioned some things that are happening, the great success in Arizona at doing a recognition bill. So these recognition bills, Arizona's is pretty broad, but can exist in narrower forms in a lot of places, or also can be broad. I think in Arizona it might not cover healthcare professions. Florida here in 2020 did a reform to allow barbers from other states to be recognized by the state of Florida. So that's a great step. Of course, we'd love to see more universal recognition, saying for all licensed professions, but that's a great first step. There's also the possibility of just lowering the fees, looking at the education components. Why does it take 2,000 hours in some states to become a cosmetologist and only 1,000 hours of training in other states? So a lot of states are looking at things like that kind of on an individual basis. And I'll mention this bill a couple times, but in 2020, Florida passed a really big package of occupational licensing reform. So that did include kind of readjusting some of the educational requirements for a number of occupations. We've seen other success in states like Virginia with just permitting reform, at least making the process very transparent and fast so that someone who's waiting to get their license knows what to expect, knows how much to pay, knows who to pay, and knows exactly how long it'll take to get an answer. That's really important, especially if you are someone moving to other states. You would want to know that if you work in a licensed profession. Another thing that a lot of states are doing when they can't do full universal recognition is recognition of licenses from out of state for military spouses. That is hard for legislators to vote against. We all want to support military families, and so that's a great first step to do that, and then hopefully transition to a more universal recognition bill. And then something that Kim Kardashian, I think maybe has also worked on, is related to second chance laws. So don't make a criminal conviction a bar from getting a license. There should be an individualized determination in those cases. And so a lot of states have been reconfiguring the authority that the boards who oversee the licenses have in granting or denying licenses. So in theory, we'd like to give them a lot of discretion, but not if that means they're the captured industry keeping out all the newcomers. So I think I'm gonna stop there and make sure we have time for a question or two. But thank you so much, everyone, for coming to listen tonight.
Yeah, so we're going to have Katie and Savannah walking around. If you have a question, please raise your hand.
All right. Thank you all for coming. We're all blessed to have you guys come speak to us. My question is kind of, we spoke about kind of like I don't want to say the sillier licenses, like for example, florists and stuff. I'm curious to see what you guys have to say when it comes to like a doctor or a lawyer. for the most part, I agree with just about everything you guys have said when it comes to occupational licensing. I guess for me, it's more like when I talk to my friends who are doctors and lawyers, how can I explain it to them why it's bad, in a better way, I guess. Thank you.
Well, we could be here all evening with the history of how the American Medical Association transformed the medical industry in the United States about the turn of the 20th century. And you could view something you could easily view from the lens of either public interest or lens of personal interest of the profession. Probably a mixture of both. There were some studies I remember about 20 years ago that showed that there were both public health benefits, but also some real rent seeking, even the original reconfiguration of American medicine at that time. And a couple of examples I would point out. This is a little bit off of physicians, but dentists. They're very, I don't know if there are any, but there are very few states in which the person who cleans your teeth can open his or her own practice and not have a dentist on site. Two states. Now, why is that? I mean, I don't know about you, but I go in and have my teeth cleaned. The dentist comes in and says, "I hear everything's fine," and goes out. Right? Now, even if you required that once every 2 years, that in order to continue to use the service, you had to go to a dentist or have a dentist come in. It really makes no sense to say that a person who cleans your teeth, a dental hygienist, has to operate inside a practice that's owned by a dentist and have the person pay a fee for that dentist sticking his or her head in the door and saying everything's fine. Well, that's something you can, that's maybe not hardcore medical, but it kind of raises some of the issues. The other issue I think is we have personal experience with here at FSU. Good thing to tell your medical friends. I started out at the University of Arizona in 1980, and at that time, only a few years before, the University of Arizona had gotten the most recently accredited medical school in the United States. Getting a new medical school is quite hard. In fact, it was a major bone of contention. You would go visit your friends in Phoenix, and I had relatives in Phoenix, and they'd say, "Tucson stole the medical school from us," because it was clear that the AMA was only going to allow one medical school into the state of Arizona, and it went to the University of Arizona, not Arizona State, and there was all this hard feeling. So fast forward, I was at Arizona for 21 years. In 2001, I came to Florida State when we were opening our medical school. And at the time, everybody realized it was going to be the first newly accredited medical school in the United States since the University of Arizona in like 1977. And the original decision of the American Medical Association was that the Florida State Medical School was not going to be accredited, at least informally. And Sandy Dallenberg, who was president of Florida State and who had previously been chairman of the American Bar Association Sub-College on Antitrust, told the American Medical Association, "See you in court." Well, it turned out that our medical school was accredited within about 6 months. And in fact, what it did, it broke the dam. It really broke getting FSU accredited broke the dam of getting new medical schools accredited across the United States. So that's an issue of medical education. It was very, very easy to see some people saying, well, this was a public interest thing, and other people saying, no, this is really this is a private interest. This is a rent-seeking activity, inhibiting the ability of people to go to medical school, raising doctors' wages, and so on and so forth. Okay? I mean, I don't know if you guys disagree, but that's kind of my experience on that. Guys?
No, I think the examples of medical school, certainly you've identified the costs. And the costs are that the professional associations really limit the ability of individuals to get in. An example of that is if you were to go through the history, one of the most important factors that would determine whether an occupation is licensed is whether they form an association in that state, and that dramatically increases the likelihood of their getting a license. So looking at professional associations is an issue. Now, getting back to your original question, should doctors be licensed? And what the cost of that might be issues of having incompetent or unscrupulous physicians who might not be able to identify a disease that could spread. So those are, that would be, you need to weigh that. As Tom Sowell famously said, there are trade-offs. And some of the trade-offs are access versus having individuals who've met some minimum level of competency, which licensing tries to assure.
And I would just say really briefly, you know, the types of things that we're seeing right now, the reforms are not going to be at that level. So, you know, whether or not you want to debate that is one thing. And whether or not licensing is helping us in professions like doctors or lawyers is one thing. But, you know, we're still talking about florists have to get a license in Louisiana, interior designers have to be registered here in Florida. So I think you can be against licensure without maybe having your mind made up about whether or not we need it for doctors.
Okay, well, it is past 7 o'clock, but I do want to ask one more question, if I can. So Florida is one of the more heavily licensed states in the United States of America. We like to think of ourselves as the free state of Florida. We've got a lot of young people out in the audience, young professionals who are about to start their career. I'm wondering how occupational licensing will affect them and whether it will affect their ability to get their foot on the rung of the economic ladder and to make the most of their lives and improve their lives in the way that they'd like.
Well, the good weasel thing is it depends. And if you want to be a coder, certainly there are very few restrictions. But if you're a coder and you want to become a certified public accountant, those are super barriers. Accounting raised the requirement from 4 to 5 years. Physical therapists raise them from less than a bachelor's degree to now you need to be a doctor of physical therapy in order to get a license. So it really depends on the occupation you're seeking to enter. There's huge numbers of unregulated, 75% of the market is unregulated, and those are fairly easy entry. But if you want to go into the 1 out of 4 jobs that you need permission from government in order to work, it is much tougher, and Florida certainly enters the top 10, if not the top 5, in being among the most heavily regulated states. There have been attempts to deregulate, including ballroom dance instructors, but that was a bridge too far, apparently.
I wonder, Jamie, you mentioned that there was a 2020 deregulation move. Can you tell us more about what some of the industries that are deregulated in that?
Sure, yeah, thanks. I do have some of them written down. So I think it repealed the license altogether, got rid of licensure for hair braiders, nail polishers, makeup artists, boxing announcers, boxing timekeepers, those are separate, and hair wrappers. It replaced the interior design license with registration, so we like that stuff. I mean, they don't even need that, but it reduces the number of hours of training for cosmetology and barber license. A lot of states are doing that. I told you it has the universal recognition for out-of-state barbers, and it reduced requirements for landscape architects, subcontractors, alarm system installers, diet coaches, and geologists. So I think, you know, Florida needs, it took a big bite of the apple there, and I think it should continue doing this work and also seeing the benefits of this. You know, we didn't talk about this, but this problem with hyper-licensure, over-licensure keeps a lot of people in the underground market operating instead of being able to open a real business, you know, doing stuff on the side or doing stuff for cash, and not being able to build a business the way that the owner would like to and the way that would help our economy the most.
Thank you all for coming out.